position of the applicant that the respondent states act of withdrawing this declaration is invalid because it violates the African Charter and it also violates the vested rights of adherents. Proceeding to issue 2, Your Excellency, Council will be advocating on whether the Republic of Edera violated the African Charter and other relevant human rights instruments by failing to ensure that the Bashi people and child workers are protected from violations committed by QHL. Your Excellency, it is the submission of the Council for the applicants that the Republic of Edera has violated these instruments, the African Charter and other relevant human rights instruments, through omission and through affirmative action by facilitating the action of the QHL, therefore breaching their duty to prevent, to investigate, and to even remedy harms to indigenous livelihoods, environmental integrity, and child protection, Your Excellency. Your Excellency, Council will be arguing this issue under 2 heads of submission: that there was a violation of the African Charter, which was a failure to protect indigenous property, development, and environmental rights. Your Excellency, it is the assertion of the Council for the applicants that the Republic of Edera has breached the African Charter, Article 14, 21, 22, and 24, by enabling KHL to forcibly displace indigenous people from their ancestral lands, Your Excellency. Your Excellency, the Bashi tribe, they numbered about 240,000 pastoralists, and they relied on the ancestral lands for livelihoods and for sustenance, Your Excellency. Your Excellency, the activities of the QHA, which included explosive mining, it was disruptive and led to forcible evictions by state agents. And even despite the recommendations of the JJC, as stated in the fact of the case, Your Excellency, Jacob Jeffrey Commission recommended settlements and mining reforms. The respondent state still allowed mining operations to resume just 5 months without compliance. Your Excellency, in the case of Enderos and Kenya, the African Commission affirmed the rights of indigenous people's collective rights under Article 14 of the Charter, and they asserted that it requires free, prior, and informed consent to exploit resources. Your Excellencies.
Council, yeah, your time is up, but I have one question for you, and I will maybe meet with the judges for us to give you 2 more minutes to answer the question outside you. You mentioned, the last case you mentioned is a case decided by the African Commission. My question to you is, of what value is that decision is honorable?
Your Excellency, being a case decided by the African Commission, the Council for the applicants humbly asserts that it is of persuasive authority to this honorable courts.
Proceed.
Much obliged, Your Excellency. Your Excellency, to conclude the second substantive issue, Council for the applicants asserted that there was a violation of the child rights instruments and the by failing to prevent hazardous child labor. Your Excellency, the respondent state has violated the African Charter on the Rights and Welfare of Child, Article 15, and International Labour Organization Convention number 138, by preventing at least 2,000 children aged 12 to 17 to engage in hazardous diamond mining as diggers in unsafe conditions, Your Excellencies. Your Excellencies, the Article 15 of the African Charter on the Rights and Welfare of Children also obligates state parties to provide legislative and administrative measures in order to protect children in situations like this, Your Excellency. Your Excellency, the respondent state has failed to protect. Therefore, they have breached the rights of the substantive rights of the Republic of Edera through these acts of child labor, through the omission and affirmative action. Council would like to seek the leave of this cause to defer proceedings to my co-counsel to elaborate on the 3rd and the 4th issue, Your Excellency.
Proceed.
Proceed.
Much obliged, Your Excellency.
Your Excellencies, F.A. Adebayo, co-counsel for the applicants. Your Excellency, on issue 3, Council argued that the Public Order Act of the Republic of Edera, Section 13, violates international human rights law. Your Excellencies, the applicant asserts that Section 13 of the Public Order Act of the Republic of Edera, requiring 14 days prior permission for protest, violates international human rights laws and provisions. Your Excellencies, This provision, enforced during the 2019 and the June 18, 2025 protests, restricts the rights of peaceful assembly, breaching Article 11 of the African Charter and Article 21 of the ICCPR. Your Excellencies, Article 11 guarantees freedom of assembly, allowing restrictions only if necessary for national security or public order. Your Excellencies, Article 21 of the ICCPR permits limitations only if it is unlawful and it is necessary in a democratic society. And Your Excellency, proportionality comes to play when considering all these things. Your Excellency, the Act's permissions necessitates requirements, not just mere notification. And this creates a state's veto, contradicting the African Commission's guideline comments for the policies of assemblies.
Counsel.
Your Excellency.
From the facts of the case, I want you to present to this court the acts of the government that were not proportional. You just mentioned the principle of proportionality. Educate the court on the principle of proportionality and relate it to the facts of the case. Thank you.
Your Excellencies, on the principle of proportionality, Counsel argues that proportionality has to do with the consideration of the context of the Republic of Edera. And by considering the context of the Republic of Edera, Your Excellencies, we argue that this relates to different things which have to be put in place before the protests may hold. Your Excellency, international standards and provision requires that there is no need for notification for citizens of the state to notify the states before they can exercise their rights of peaceful assembly. Your Excellencies.
Counsel, are you saying that there is no need for notification or there is no need for permits? Let's understand what you're saying.
Your Excellency,
or
please,
let me put my question in another way. Is there any difference between notification and permission?
On notification and permission, Your Excellency, it's necessary that notification and permission are two different things. Notification has to do with informing the government. Notification is needed, but permission, however, Your Excellency, is an arbitrary act which may be misused by the government. Your Excellency, in line with international standard and provision, notification is permitted. However, permission, on the other hand, is debatable and argumentative in this state. Your Excellency, as the state seeks to permit the protesters in this particular instance, we can look to the fact of the case and would realize that the state, in its hearing and its treatment of the issue, did a kangaroo hearing. Your Excellency, we affirm that the state is not right in this regard. The state has derogated the rights of those people, requiring such states again and subjecting the citizens of the state to permission on the part of the state is limiting their rights in some ways, Your Excellency.
Proceed.
Much obliged, Your Excellency. Your Excellency, furthermore, the case of Law Association of Zambia versus Attorney General held these similar notification laws that it should be done in a discretionary way. And it was held in this case that if it is prohibitory, it violates Article 11 of the African Charter. Your Excellencies, the application of the Public Order Act led to excessive force in 2019 and 2025, where unpermitted assemblies triggered shooting, killing 5 and injuring 30 other citizens. Your Excellencies, the Edera Constitution incorporates ratified treaties binding on the Republic of Edera to align domestic laws with international standards. Your Excellency, the inconsistency of the Public Order Acts and specifically Section 13 with the African Charter and the International Covenant on Civil and Political Rights renders the Public Order Acts valid, and it means that this is a way of denying Ederans their fundamental rights. Your Excellencies, we ask Your Excellency, we ask that this Public Order Act, and specifically Section 13, is declared incompatible and inconsistent with international human rights and international human laws. Your Excellencies, on issue 4, the applicants argue that the Republic of Benin violates the African Charter and other necessary human rights instruments in the treatment meted out to Mr. Jude, to the persons of Mr. Jude and Mr. Marcos. Your Excellencies, the environmental and human rights defender submits that the Republic of Benin violated this instrument by deploying disproportionate military force against the peaceful assembly. Your Excellency, this affects arbitrary detention without due process, and it poses a politically charged conviction that denies fair trial, that denies legitimate advocacy, and the likes. Your Excellency, in canvassing our argument, we shall be relying on 3 heads of submission. Your Excellency, firstly, we maintain that the Republic of Benin violates the freedom of assembly and the right of association of Mr. Jude and Mr. Marcos through the use of the excessive.
What's your authority for that assertion?
What's your authority
for that assertion? The last statement you made, that the Republic of Benin violates the right. What's your authority for that assertion? Show me
Your
from
Excellency,
the authority before you.
Your Excellency, we rely on African Charter Article 10.
What does it say?
It speaks on the right of freedom of assembly, Your Excellency.
Are there exceptions to that rule?
That there are exceptions to the right of freedom of assembly.
Tell the court the exceptions and how it relates with this matter in view. Thank you.
Your Excellencies, the freedom of assembly is not an absolute right. Obviously, it's not an absolute right, and the exception that may arise would be in cases where the national security is threatened, in a place of environmental disaster, in a place where such person who are supposed to be beneficiary of such rights are criminally responsible for certain acts which have been committed in previous times. However,
Counsel, are you saying that by virtue of the fact in view, are you saying that the Republic of Benin did not do that in the interest of the state?
Yes, Your Excellency, we affirm that, sir. That this exception were not considered before the rights of Mr. Jude and Mr. Marcos were violated.
I'm saying to you, Counsel, that you should please take to me the exceptions that guide that right. You just confirmed that the right is absolute. So you are now saying to me that there are exceptions. And I'm saying to you that, are you saying to this court that the court did not look into or consider those exceptions before they determined that before they took the decision they took?
Yes, exactly, sir. Exactly, Your Excellency.
Proceed.
Much obliged, Your Excellency.
Proceed.
Your Excellency, General Anthony deployed armed special forces who fired live ammunition, injuring 30 and killing 5 civilians, as per the report given by the NGO. Your Excellency, this is a disproportionate response, violating the duty of the state in facilitating the protection and promotion of the freedom of assembly of citizens under General Comment number 37 and African Commission guidelines. Your Excellency, we rely on the case of Woza versus Zimbabwe, where the African Commission found that the violation of Article 11, where police used excessive force against women protesters, thereby emphasizing state obligation to protect participants. Your Excellency, the earlier mentioned case of Kazin Gachiri versus Zimbabwe, it was held there that arbitrary arrests during peaceful assembly and protests infringe Article 6 of the African Charter, which thereby requiring individualized suspicions. Your Excellencies, from the foregoing, we can deduce that Mr. Jude and Mr. Marcos's detention post-shooting without evidence of personal violence exemplifies reprisal against these leaders. Your Excellencies, as they are marginalized. Your Excellencies.
What will you call arbitrary arrest? If the state found themselves in a situation where there was chaos. Are you saying they should have allowed everybody to just go on rampage and do whatever they like? So what is your definition of arbitrary arrest?
Your Excellencies, from the facts availed us, the person of Mr. Jude and Mr. Marcos rightfully were at the front line of this protest. However, Your Excellency, the fact records that there was the involvement of touts, loud area boys throwing and going against police authority. Your Excellencies, with the force used by the states by sending military men and the army by deploying them into this place. Your Excellency, they could have arrested the people who actually performed this act, who are perpetrators and who were destroying governmental properties. However, Your Excellency, in a charged manner, the states sought after and went after the persons of Mr. Jude and Mr. Marcos. This raises individualized suspicion. Your Excellency, the arrest is arbitrary by every means.
Proceed.
Much obliged, Your Excellencies. Your Excellencies, we assert that there is a violation of the liberty and security of Mr. Jude and Mr. Marcos through their arbitrary detention. The immediate arrest by the live armed troops contravenes African Charter Article 6 and Article 6 and the ICCPR Article 9, thereby which prohibits arbitrary deprivation of liberty. Mr. Jude and Mr. Marcos endured incommunicado-like conditions and systemic judicial delays in this regard. Your Excellencies, we would like to speak on the violation of their fair rights trials, which seem politically motivated. There were politically motivated prosecution and conviction of the person of Mr. Jude and Mr. Marcos. Your Excellencies, the Republic of Edera's trial process violates African Charter Article 7 and the ICCPR Article 14, which thereby deny the presumption of innocence, which is necessary, the adequate defense, which is to be availed of these people, and the appeal. Your Excellencies, Mr. Jude and Mr. Marcos were charged solely as organizers, despite the fact that there was no direct involvement in the destruction of these properties. Your Excellencies, they also received a mandatory 3-year sentence without fine.
Counsel.
Your Excellencies.
Counsel. The properties that were destroyed, can you please tell the court the premise for the destruction?
Your Excellencies, relying on paragraph 12 of the facts, we're told that area boys retaliated by throwing stones at the police officers, thereby breaking the vehicle's windscreen and causing head injuries to the 2 policemen. Breaking the vehicles.
Counsel, will you agree with me that the protest was what gave advantage to the hoodlums to perpetrate injustice on government properties?
Right, sir.
Proceed.
Right, sir.
Proceed.
Much obliged, Your Excellencies. Your Excellencies, on attribution and positive obligation on the part of the Republic of Edera, Your Excellencies, under African Charter Article 1, the Republic of Edera must prevent and remedy violation. Its facilitation of violence via the deployment of military and the non-persecution of the forces in this regard, it attributes state responsibility. Your Excellency, the treatments form part of a pattern suppressing the Bashi advocacy and in line with foregoing events. Your Excellency, we demand justice on behalf of those people. Your Excellency, with our foregoing arguments, Your Excellency, Your Excellencies, Council seek to adopt our prayers. We seek 3 minutes more to adopt our prayers. 2 minutes more, rather.
Proceed. 2 minutes.
Your Excellency, we seek that this noble court declare the Republic of Edera's withdrawal of Article 34(6) invalid, that the Republic of Edera is ordered to reinstate the declaration. We pray this honorable court that Section 13 of the Public Order Act is made incompatible or declared incompatible with Article 11 of the ratified African Charter and Article 21 of the ICCPR. Your Excellencies, we pray this honorable court to order the Republic of Edera to amend the act to comply with international standard and provisions. Your Excellency, we also seek as much relief as may be thought needed by this honorable court.
Thank you. Thank you, councils. The time is up.
Team 16, you can comment.
Most obliged, Your Excellencies. With profound respect to this honorable court, I am AA Owoyemi, and appearing with me is OO Bamidele. We humbly appear on behalf of the respondent state. With the kind permission of Your Excellencies, I'll be using 17 minutes to address the preliminary issues of jurisdiction, admissibility, as well as the merits of claims A and B. Now, with Your Excellencies' kind permission, I would like to proceed with my submissions.
Sorry, Team 16. You wrote in the chat box that your oralist 2 is Dele Ogundijo. Has that changed?
No, Your Excellency. She's OO Bamidele.
In the chat box, you can check your oralist 2 is written as Dele Ogundijo, 13 minutes. And oralist 1, Abdul Mujib Owoyemi, 17 minutes. That is what you have there. So what has changed?
I'm the oralist 1, Your Excellency.
What's your name?
You are Abdul Mujib?
Yes, Your Excellency.
So who is Dele Ogundijo in the chat box as oralist 2?
She is the oralist 2, Your Excellency.
What's your name? Oralist 2.
Your Excellency, my name is Dele Ogundijo Oluwabusayomi.
Oh, because
okay.
I think
but your Ogundijo was not announced as your surname just now.
Very well.
My initials were announced, Your Excellencies. Bamidele.
So what is your surname? Bamidele Ogundijo?
Ogundijo.
Bamidele Ogundijo, Your Excellencies.
Is a compound name?
Yes, Your Excellencies.
Thank you.
Okay. Thank you.
Much obliged.
Most obliged, Your Excellencies. Now I will proceed with my submissions on the jurisdiction of this honorable court. To begin with, Your Excellencies, this honorable court stated in Jeba Kembole against the United Republic of Tanzania that the court shall observe whether it has material, personal, temporal, and territorial jurisdiction. Your Excellencies, while we admit that this honorable court has jurisdiction on material, territorial, and temporal aspects, we firmly contend this honorable court's personal jurisdiction.
Counsel.
Yes, Your Excellency.
Okay, you can put off your video if your network is unstable so we can hear you, because it's breaking right now. Otherwise, you may proceed.
All right, Your Excellencies. Your Excellencies, on the personal jurisdiction of this honorable court, Article 5, Paragraph 3 of the court's protocol provides that the courts may entitle relevant NGOs with observer status before the commission to institute directly before it in accordance with Article 34, Paragraph 6 of the protocol. Your Excellencies, Article 34, Paragraph 6 then provides that the state party must have made a declaration accepting the competence of the court to receive such cases. Your Excellencies, the court shall not receive any petition involving a state party which has not made such a declaration. Your Excellencies, it is evident from the facts of the case that while EDERA ratified the court's protocol and made the declaration initially, President Simforosa subsequently made an announcement withdrawing the acceptance of the jurisdiction of the court. We therefore respectfully submit that such announcement is valid under the protocol and such as the effects of stripping this honorable court of its personal jurisdiction over this matter. Therefore, Your Excellencies, it is our firm submission that since this honorable court lacks the personal jurisdiction, its possession of other jurisdictional powers would not suffice to hear this application. And as such, this honorable court lacks jurisdiction to hear this application. With Your Excellency's kind permission, I would like to proceed with my submissions on the admissibility. Yes, Your Excellency.
Counsel,
yes, Your
you have
Excellency.
stated that the withdrawal is legal.
Is legal, yes, Your Excellency.
Yes. Is there a provision,
yes,
or is there a procedure? Is there a procedure, under the charter or the protocol for withdrawal of ratification?
Your Excellencies, while I would like to notify the court that we will be addressing...
Secondly, you need to also come in clear terms to show to this court why we lack jurisdiction. It's not enough to just say the court lacks jurisdiction. What's the authority that binds your argument that this honorable court lacks jurisdiction to entertain the application? Counsel.
Thank you very kindly, Your Excellencies. Your Excellencies, while this Article 5, Paragraph 3 of the court protocol provides that this honorable court shall have the personal jurisdiction of this honorable court has to do with, is tied to the respondent state's ratification and acceptance of the court's jurisdiction. In a case whereby the respondent state has not accepted the jurisdiction of this court to entertain matters from NGOs, then this honorable court would not be entitled to receive such applications. And we stated earlier that this the respondent state, the president of the respondent state, has made a withdrawal, an announcement declaring the withdrawal of their Article 34, Paragraph 6 declaration. Your Excellencies, more of this will be discussed under Merit A of our subsequent arguments, Your Excellencies.
Counsel, are you aware that the NGO has an observer status?
Yes, Your Excellencies.
So address me on that.
Yes, Your Excellencies.
Address the court on that.
Yes, Your Excellencies. Their observer status grants them the ability, according to the African Charter, the protocol to the African Charter, it grants them the power to institute before this honorable court, provided that the respondent state has made a declaration accepting the jurisdiction of this honorable court. In absence of such declaration, this honorable court would not be entitled, would not have the power or jurisdiction to entertain such matter from any such NGO. May I proceed, Your Excellencies? Most obliged, Your Excellencies. With Your Excellencies' kind permission, I will now proceed with my submissions on admissibility. Your Excellencies, regarding admissibility, we submit that this application is inadmissible. Our reliance is placed on the provisions of Article 6, Paragraph 2 of the court's protocol, which mandates that the court shall rule on the admissibility of cases, taking into account the provisions of Article 56 of the Charter, of the African Charter. Your Excellencies, in addition to this, in the case of beneficiaries of Nobel Zongo against Burkina Faso, the court held that an application is inadmissible if it does not meet all the requirements stated under Article 56 of the African Charter. Your Excellencies, the contentious ones in this case are the provisions of Paragraph 4 and 5 of Article 56 that provide that the application must not be based exclusively on news disseminated by the mass media, and also that local remedies must have been exhausted. Your Excellencies, on the first ground, by virtue of, Your Excellencies, we submit that the human rights violations complained of by the applicant are exclusively based on the news disseminated by truth defenders. Your Excellencies, the publications made by truth defenders are such that they must be considered cautiously. They are tailor-made to suit press reports, and as such, most of the publications contain untrue facts, which are either over-exaggerated or non-existent. Your Excellencies, it will therefore be unjust and unreasonable to base the foundation of this application on falsehood. On the second ground, Your Excellencies, regarding the exhaustion of local remedies, we rely on this honorable court's jurisprudence in the case of African Commission against Kenya, where the honorable court stated that the purpose of exhausting local remedies is to afford the respondent state of an opportunity to redress the alleged violations and to prevent the court from being a court of first instance. Your Excellencies, we therefore submit that the applicant failed to exhaust local remedies with respect to Claim B in this application. Your Excellencies, according to the Constitution of Edera, the Supreme Court has the power to entertain appeals that lie directly from the Court of Appeal. However, when MAPAO instituted an action for further compensation for the various violations suffered from QHS mining activities, the High Court found the case in their against their favor, and the Court of Appeal upheld this decision. However, they did not further approach the Supreme Court for any other redress, but they could be deemed to have accepted the decision of the Court of Appeal as the truth of the matter. Your Excellencies, the Court of Appeal is not the final court of record regarding civil cases in Edera. Thus, relying on this honorable court's jurisprudence in Southern African Human Rights NGO Network and others against Tanzania, it is premature for the applicant to bring the present application before an international body, given that he still has internal remedies at their disposal. Your Excellencies, we therefore submit that MAPO's failure to approach the Supreme Court clearly reveals the failure of the applicant to exhaust local remedies available in the respondent state, thereby making the present application
Counsel,
admissible. Yes, Your Excellencies.
would you want to educate this court on the exceptions to exhaustion of local remedy? Because you have stated that they did not exhaust local remedy. Couldn't it have been that they considered the exception, that's why it was not exhausted?
Your Excellencies, the exceptions to the exhaustion of local remedies are that if the case could have been unduly prolonged, or that the remedies would be ineffective, or any other such, or as the case may be. Your Excellencies, in this case, there is no evidence to show that any remedy would have been unduly prolonged, or that if they had approached the Supreme Court, there would have been a sort of unjust remedy available to them. As thinking about it this way would be mere assumption and would not be the truth of the matter, Your Excellencies.
Proceed.
Most obliged, Your Excellencies. With Your Excellencies' kind permission, I would like to proceed with the merits of Claim A.
Proceed.
Your Excellencies, the applicant claims that the withdrawal by EDERA of its Article 34, Paragraph 6 is invalid, as it violates the African Charter and other relevant human rights instruments by undermining the rights of adherents. Your Excellencies, on this issue, we submit firstly that the withdrawal does not undermine the vested rights of adherents. Rather, it was done in the exercise of the state's sovereignty. And secondly, that President Simforosa actually had the power to make such withdrawal. Your Excellencies, on the first ground, Article 34, Paragraph 6 is clear, and it provides that states can make a declaration accepting the competence of the court to receive cases, and that the court shall not receive any petition involving a state party which has not made such a declaration. Your Excellencies, it is clear from this provision, it is clear that this provision seeks to restrict the powers of the court to interfere with the affairs of state parties which are unwilling to have the court meddle with their business. The idea of voluntary declaration by the court protocol represents a respect for the sovereignty of state parties to the Charter. Your Excellencies, this argument is further supported by this Honorable Court's view in the case of Ingabire versus Republic of Rwanda at paragraph 57, that the optional nature of the declaration and its unilateral character stems from the international law principle of state sovereignty. The court further held in that case that as far as unilateral acts are concerned, state sovereignty demands that states are free to commit themselves and that they retain the discretion to withdraw their commitment. Your Excellencies, based on the view of this Honorable Court in the case cited, it is safe and reasonable to say that the respondent state may denounce its declaration pursuant to Article 34, Paragraph 6, and such withdrawal is valid under the protocol. Your Excellencies, it is important to point out at this juncture that the said withdrawal was not intended to undermine the vested right of adherents, neither does it have any such effect. This is because the withdrawal only affects the jurisdiction of this Honorable Court and not the rights guaranteed by the African Charter and other relevant human rights instruments. Your Excellencies, Article 1 of the African Charter provides that the member states shall recognize the rights and freedoms enshrined in the Charter and shall undertake to adopt all means to give effect to them. We submit that the people's rights are still recognized and protected under the adherent justice system. In a bid to comply with Article 1, yes, Your Excellencies.
The applicants they've argued that if the effect of the withdrawal would mean that they will not have access to this court, in a way, it's a deprivation of their rights. Don't you think so?
We do not concur to that argument, Your Excellency. This is because the justice system in EDERA is enough to redress any human rights wrong that they might have been facing. Your Excellency, this is evident from the fact that in each state in the Republic of EDERA, there exists a high court which is saddled with which is given the power to entertain all cases, including human rights violations. And also, if you are not satisfied with whatever you get from the High Court, you can definitely approach the Court of Appeal, which hears appeals from the High Court. And also, if the person is not satisfied with that, there is still the Supreme Court, which is available in the country, that hears appeals from Court of Appeal. So we do not believe that the mere fact that they are unable to access just the African courts would deprive their rights to access justice, Your Excellencies. Yes, Your Excellencies.
Are you premising your argument on the fact that the applicant lacks jurisdiction in this court because they didn't approach the Supreme Court? Is that your argument?
Yes, Your Excellency. As earlier stated, it is pertinent for the applicant to first exhaust local remedies. Where they do not exhaust local remedies, it strips this honorable court of the jurisdiction to hear the application. In this case, they did not further approach the Supreme Court to seek a remedy. Instead of doing that, they approached this court, skipping a step which was actually required, Your Excellency. May I proceed, Your Excellency?
Proceed.
Based on the foregoing, Your Excellencies, based on the foregoing, Your Excellency, we submit that the withdrawal of declaration under Article 34, Paragraph 6 is valid and does not undermine the rights of adherents. As such, does not violate the African Charter and other relevant human rights. Moving on, Your Excellencies, we submit that President Simforosa actually had the power to make the withdrawal. Your Excellencies, Section 17 of the Constitution of the Republic of Edera says that the President has the power to ratify treaties and agreements. However, treaties or agreements that concern international organizations or affect the vested right of adherents can only be ratified upon approval by the Parliament. Your Excellencies, it is clear from this provision that the provision is silent as to the power of the President to solely withdraw such treaties or membership. It is therefore our submission that this restriction does not extend to his power to withdraw such ratification. Thus, the respondent firmly submits that the provision of Section 17 does not affect the President's power to withdraw the declaration. Therefore, Edera's withdrawal of its declaration is valid. It does not undermine the vested rights of adherents, and as such, does not violate the Charter or other human rights instruments. I humbly seek Your Excellencies' kind permission to proceed with the merits of Claim B. Your Excellencies, our submission on Claim B is based on two standpoints. First, that the respondent state has duly discharged its duty of due diligence with regards to the alleged violations committed by QHL, and as such, they cannot be held to have violated the African Charter on Human and People's Rights. On the first ground, Your Excellencies, in Zimbabwe Human Rights NGO Forum against Zimbabwe, the African Commission at paragraph 147 described the doctrine of due diligence as the threshold of action and effort which a state must demonstrate in fulfilling its responsibility to protect individuals from abuses of their rights. Your Excellencies, I crave the indulgence of this honorable court to give me just 2 minutes to wrap up with my presentation, Your Excellencies.
Proceed.
Much obliged, Your Excellencies. Furthermore, Your Excellencies, the Inter-American Court of Human Rights in the case of Velasquez Rodriguez against Honduras stated that the state is required to take reasonable steps to prevent human rights violations and to use the means at its disposal to carry out a serious investigation of violations committed within jurisdiction, and also identify people that are responsible and impose punishment to ensure that the victims are rightly and adequately compensated. Your Excellencies, it follows that the respondent state will only be responsible if they fail to carry out due diligence of investigating the violations, punishing the offenders, and redressing the wrong suffered by the victims. Your Excellency, it is evidence from the facts of the case that upon the unfortunate incident that took place in 2019, the respondent state set up a judicial inquiry committee, which was the Jacob Jeffrey Commission report, which made recommendations, which the respondent state took up immediately and adopted the recommendations and implemented them. Your Excellencies, also, the respondent state, upon hearing news about child labor and child economic exploitation, they set up the Edera Mining Board, made investigations into the matter and found the matter to be false, baseless. Your Excellencies, it is on this point that we submit that this respondent state cannot be held responsible for the violations committed by QHL. With the leave of this honorable court, I would love to The fair proceedings, my co-counsel.
Proceed.
With profound respect to the Honorable Court, Your Excellencies, I am O.O. Bamide Esquire. I seek for this Honorable Court to proceed on the operation of the following two issues alongside the reparation and conclusion, Your Excellencies. Your Excellencies, on the question of whether the Public Order Act of the EDERA violates international human rights law, the respondent responds in negative. The respondent contends that the Public Order Act of the Republic of EDERA has not in any way violated the international human rights law. This act is constitutional and in conformity with international human rights law standard. Admittedly, Your Excellencies, the international human rights law has recognized the rights of citizens of state of international organizations to hold peaceful assembly. The right to this assembly is entrenched in Article 20, Sub-1 of the Universal Declaration of Human Rights, Article 12 of the African Charter on Human Rights, and Article 11 of the African Charter on Human Rights and People's Rights, and Article 21 of the International Covenant on Civil Rights and Political Rights, Excellencies. Notably, Article 1 of the African Charter requires that member states have the duty to protect the rights guaranteed by this charter. However, the court in Tanzania Law School Society and others against Tanzania stated that where this protection comes into action.
Can you please speak? The court is writing, noting your argument. Please go softly. Go ahead, counsel.
Noted, Your Excellency. Notably, Your Excellencies, Article 1 of the African Charter requires that member states have the duty to protect the rights guaranteed by the Charter. However, the court in Tanzania Law Society and others against Tanzania stated that where this protection comes into action, they have a greater duty to preserve the right of persons to life, health, and satisfactory environments. A member state is allowed to limit the rights to persons on the ground of collective security, morality, and common interests. Your Excellency, this has been established in Article 27 of the African Charter. Your Excellencies, the principal provision of right to assembly, Article 11 of the Charter, while generally rigid in protecting citizens' life to peaceful assembly, allows flexibility in certain circumstances. Specifically, restrictions may be imposed by law to protect national security, public safety, and public order where these interests are threatened. Based on the foregoing, a law passed in conformity with the law or measures taken by the authorities to ensure general public safety is considered necessary and proportional and cannot be considered as infringement of individual rights or any violation of international human rights law. Your Excellencies, this was why the court in Ovequena and others against Russia was clear when it emphasized that interference with the exercise of freedom of assembly or freedom of expression can consist in various other measures taken by the authorities, including measures taken before or after. In application to this case, Your Excellencies, the law passed by the Republic of EDERA mandating that the resident of Bashi to give a 14-day notice to the Office of Inspector General is a necessary measure taken before the Assembly to ensure public safety, public order, and national security of the people of Bashi. The full compliance with this law will ensure conformity with other law of the state that protesters are oblivious of, and to prevent crises like vandalism of government property, like the one that was committed Mr. Jude and Mr. Marcos. Subsequently, Your Excellencies, certain conditions has been prescribed by the African courts for a formal notice of protest not to be regarded as encroachment. The court was clear in Williams against Zimbabwe, following the provision of legitimate aim. Also, the court in Jennifer Williams and others against Republic of Zimbabwe emphasized the importance of necessity and proportionality, Your Excellencies. The respondent respectfully submits to this court that this element has been met. Firstly, if a state proves a legitimate aim for restriction on assembly by cause of formal notice, such requirements cannot be considered as violation of international human rights law. It is fundamental to note that legitimate ground for restriction. Yes, Your Excellencies.
Okay, just take it easy because we are struggling to follow you. Okay, my question to you is was it a notification of permission that was required from protesters?
A notification. A notification.
Can you take us to the paragraph?
And if it's secondly, corroborating my learned brother, if there is notification, can you show to us if they got it? Network, are you there?
Your Excellencies, I'm struggling to hear you. I'm struggling to hear you, Your
My learned
Excellency.
brother just asked the question to show us the paragraph where it was. Now, I'm not asking that, can you show to us if the applicant got it?
Your Excellency,
Network is bad.
Article, Your Excellency, are you with me?
Go ahead. I'm struggling to, your network is not, go ahead. Can you hear me?
Yes, I can.
All right,
Can you
please
hear
go
me,
ahead.
Your Excellency?
Yes, I can. You can. Go ahead.
Yes, paragraph 1 of the case stated that ahead of the night of April 2019, the Inspector General of Police, Mr. Kelebe, put out television and radio statements to one resident of Bashi not to follow the provision of Section 13 of the Public Order Act, which requires organizers of any protest to secure permission from his office, at least.
Cancel.
Nevertheless, as planned, on the
Cancel. Hold on.
the protest.
Are you reading from facts? Are you reading from facts?
Yes, Your Excellency.
So from what you just read, is it permission or notification that was required?
Yeah, you can. Your Excellency, it was required that they notify the office of the Inspector General of Police to secure permission from his office at least 14 days before the protest.
And was that done?
This council respectfully submit to the wisdom of the No, Your Excellency. The applicant failed to seek permission from the office of the Inspector General of Police before they went ahead with the protests.
Is it
Cancel.
is it permission or notification? That's the
Yes,
question Malene just asked you.
that's the question I'm asking. Because under international law, there's a hold on, Council. Under international law, there's a difference between notification and permission.
And consent or
And I
permission,
just yes, I just asked you, and you said it was notification. But in another breath, you are saying it's permission. Kindly give us the right position, please.
My lord, this council submit the wisdom of this honorable court. Permission, Your Excellencies. Your Excellencies, can you hear me?
I'm struggling to hear you. Network is, exactly.
Yes,
your network is bad. I'm struggling to hear you. But in case you can hear us, what my learned brother asked you is what please give an answer to that appropriately.
Your Excellencies, the Inspector General of Police required the resident of Bashi to come to the office to seek permission before they can go ahead with the protests.
So,
Permission,
based on what
Your Excellencies.
said, yes, based on what you have said, was it permission under international law? Is it permission or notification that is required?
Yes, Your Excellency. A formal notice of protest. Under international law, a formal notice of protest is required.
So in this instance, why were they requesting for permission instead of notification?
Council, they calm. Hello, Council. You are becoming agitated.
Yes,
you need to calm. Take a deep breath. Take a deep breath. Be calm. You are struggling with your words, and it's becoming very hard for us to hear you. Now, you have not answered the question of my learned brother. You are mixing it up. Notification and permission, using them interchangeably. Are you saying they're the same words under international law?
Your Excellencies, I gave an answered the question already. I said we are required to seek permission from the Office of the Inspector General of Police. Me that why were they requiring a notice? And I said it is fundamental for them to send a notice to the office before they can get their permission. It's right. I note is sent to permission.
Council, proceed because of time. Proceed. You may proceed.
If a party puts a legitimate aim for constitutional assembly because of formal notice, such requirements cannot be considered as violation of international human rights law. It is evident that legitimate ground for restriction shall be limited to those in the of the charter, including national security, public safety, and public order. Restriction may be necessary in any democratic society. When it's required, it's fundamental that the same party prove necessity and proportionality. The necessity has been proved by the legitimate aim to ensure public safety and order, and the 14th day notice is reasonably proportional. Your Excellencies, the purpose of this formal notice was not a means to put an end to the protest, but to ensure effective preparation, compliance, and conformity with the law. Given the above, Your Excellencies, to protect the rights, the public interest, and public order of the people of the law of 14 days of formal preparation before protest is reasonable and in conformity with the law. Therefore, the respondent argues that the public order act of the Republic of Nigeria is in conformity with international human rights standards. I see if the Honorable Court to proceed with the last issue.
Proceed.
Proceed.
What obliged exercises? The legal question of whether Nigeria violated the African Charter and other relevant human rights instruments by treated out to Mr. Jude and Mr. Marcos, the respondent affirms that no treatment was meted out to Mr. Jude and Mr. Marcos. Thus, there was no violation of African Charter and other relevant human rights. The respondent asserts that action taken by Nigeria was in conformity with international standards. The respondent further argued that the parties were lawfully arrested contrary to the allegation of the raised by the applicant in contravention of Article 6 of the African Charter. The arrest, arraignment, and sentencing is proportional and justified. The court is clear in the landmark case of Oyenachi and Onjoka against Tanzania, where it commented that the notion of arbitrariness under the of the Charter also covers the deprivation of liberty, contrary to the standard of reasonableness. That is, it is fundamental to inform us whether such arrest is just, proportionate, and equitable. These are also the courts in the case of wrong against Cameroon. And establish international human rights jurisprudence sets stipulative criteria to determine whether or not a particular deprivation of liberty is arbitrary, and they include lawfulness of the deprivation, existence of a clear and reasonable ground, and availability of procedural safeguards against arbitrariness. Firstly, the of lawfulness of deprivation of liberty, the respondent submits that this requirement has been met. An arrest that has a firm legal basis cannot be considered as arbitrary. The court in a sono mica against Equatorial Guinea. Your Excellencies, I seek the indulgence of this honorable court to conclude my issue under 3 minutes.
Proceed.
Proceed.
Your prayers and conclusion.
Most obliged, Your Excellencies. The respondent posits that this arrest is not in accordance with the law. Additionally, Article 6 explicitly requires a reasonable ground for arrest. However, different reason and condition implies that the detention should be based on adequate detention. Your Excellencies, the principle was established by the court, only legal and others against them, as stipulated in the relevant provision of right to assembly. Any assembly must be peaceful, and authorities can get involved once it is a threat to the public. Finally, respect to the criteria of availability of procedural safeguards against arbitrariness. Your Excellencies, it is fundamental to respectfully remind this honorable court the words of the court in Thomas against United of Tanzania, where it was provided that detention after trial and conviction in a criminal trial does not violate the prohibition of arbitrary detention unless there has been a flagrant denial of justice. Notably, the fulfillment of the third element is also in compliance with Article 14 of the ICCPR, where it was stated that everyone shall be entitled to a fair and public hearing by a competent and independent court. Your Excellencies, the respondent respectfully submits to this court that in this case, the parties were lawfully arrested and arraigned for impartial judiciary. During the course of this detention, the parties were not beaten or stabbed. No record of torture has been presented to this court by the applicant. In respect to the definition of article of detention against torture, there is no definite evidence given to us by the applicants as regards Mr. Jude and Mr. Marcus being tortured. In light of the foregoing, Your Excellency, the respondent brings to the consideration of this court that the state parties has not meted any treatment to Mr. Jude and Mr. Marcus. With respect to this foregoing submission, the respondent this honorable court to find, adjudge, and declare that the Edera withdrawal of its declaration under Article 34 is valid. The Edera has not violated the African Charter, that the Edera does not violate international human rights.
All right.
The applicant respectfully submits
Time up. Okay. All right. Can we get team 16 and team 18 to listen to the commendation of the judges?
Sir, there's time for rebuttal.
A rebuttal. That's true. Yes. Oh, sorry. Thank you, Leonard brother. All right. Team 18.
Your Excellencies, counsel for the applicant here. Your Excellencies, on the preliminary question of jurisdiction, the respondent's purported withdrawal of the Article 34.6 declaration on 15th August 2025 was shown to be wholly ineffective. Your Excellencies, the court's consistent practice by the holding in Rwanda through Tanzania and Cote d'Ivoire, and particularly the case of Inagbire versus Rwanda, Your Excellency, unequivocally requires a mandatory 1-year notice period following formal notification to the African Union. Your Excellency, no such notification was ever deposited, coming as it did just 1 week after the leader event of 18 June 2025 and the conviction of the protest leader. Your Excellencies, the withdrawal risks of bad faith designed to insulate the state from accountability. Your Excellencies, on the issue of admissibility, Your Excellency, the respondents claim that the applicant did not exhaust local remedies, and this claim, Your Excellencies, are rather incorrect. Your Excellencies, they exhausted local remedies up to the Court of Appeal. Your Excellencies, according to paragraph 6 of the MOOT Fact, Your Excellencies, the jurisdiction of the Supreme Court is confined to appeals in which a sentence of 6 years or more has been issued. Your Excellencies, the case in this regard, it was only 3 years that was issued to the persons of Mr. Jude and Mr. Marcus. Your Excellencies, on issue 1, Your Excellencies, the unilateral act of withdrawing the declaration by the President Sanforisa, is invalid because the Constitution provides that declaration may not only be made after the Parliament. Your Excellency.
The respondent argued that your coming to this court is inappropriate and that you have not exhausted local remedies, that it's incorrect for you to have approached this court when the Supreme Court, you have not filed anything before them. So please address this court on why that didn't happen.
Your Excellency, the jurisdiction of the Supreme Court in this regard are only for cases or sentences which has been made by the Court of Appeal in regard of 5 years, made. Your Excellency, in this particular issue, it was only 3 years that was made. The person of Mr. Jude and Mr. Marcus were sentenced to 3 years imprisonment, Your Excellency, which does not meet the merit of the Supreme Court, Your Excellency.
Proceed.
So in this regard, much obliged, Your Excellency. Your Excellency, the unilateral act on issue 1, the unilateral act of withdrawing the declaration is invalid because the Constitution provides that declaration may only be made after Parliament's approval. Your Excellency, President Sanforisa unilaterally withdrew the commitment of the Republic of Edera from this treaty ratified. Your Excellency, the withdrawal without approval is thus invalid. Your Excellency, on issue 2, the compensation is invalid in every regard, as it is not even sufficient given the facts availed us. Paragraph 14 of the fact says that this compensation could not even cover the hospital bills of victims. Your Excellency, given this, the respondents claim that the government has fulfilled its due diligence towards Bashi communities and child workers they are only illusory claims. Your Excellencies, on issue 3,
Counsel,
on the issue
your
of
time is up.
much obliged, Your Excellency. Please, could the court please avail counsel 2 minutes to round our rebuttals up?
Proceed.
Much obliged, Your Excellencies. Your Excellencies, Mr. Ajuda and Mr. Marcos, they were not responsible for derogating or for destroying public properties. They cannot be vicariously liable for the acts of unknown louds and unknown parties. And Your Excellency, the treatment meted out to Mr. Ajuda and Mr. Marcos were laid bare as a textbook case of excessive use of force and criminalization of dissent, Your Excellencies. Deploying special forces armed with live ammunition against a largely peaceful crowd can never be proportionate. Your Excellencies, when measured against the court's own authoritative jurisprudence, every pillar of the respondent's defense collapses. Your Excellencies, in this regard, there is a breach of Article 7.1, and there is a breach of the holding of the court in the case of Alex Thomas versus Tanzania. Your Excellencies, the arrest of Mr. Judah and Mr. Marcos is arbitrary. Your Excellency, the applicants respectfully urge the court to assert its jurisdiction and declare multiple continued violation of the African Charter on Human Rights and People's Rights.
Thank you. All right, thank you. Can I request comments from my hello, Bennett brother?
Yes, sir.
Very well. I want to be sure that you are still online.
I'm here, sir.
All right. Dr. Chico?
I'm here.
Very
Sir.
well. All right. Let's just put in our words to this thing, and then we'll now round up. Then they will now exit from the platform. All right. Go ahead, sir.
Dr. Tinu, go ahead, please.
Well, for team 18, I think they did well. The analysis of the case, of the facts of the case, and the application to the facts, their legal principles, and applying to the facts of the case. I think they did well with that. I commend I'm impressed with both oralists, particularly oralist 2, and you've both done well. Well done. For the respondents in 16, I think they've also done well, but their answers to some of the questions were not so impressive. But in all, they've done well. Well done, team 16 and team 18. Thank you.
Thank you, sir. All right. Then, brother.
So I would want to commend the oralist for the job well done. I really enjoyed this session, and say, from both teams, I expected that you would refer to the facts more often. You were stating, some of the facts, but you were not making reference to the relevant paragraphs. I would advise that in competitions like this, have the facts, and the law, with you, so that when you are making reference to facts in the hypothetical case, you could direct the court to the relevant paragraph. With that being said, I would want to appreciate the effort. I know a lot has gone into preparations for this competition, so I want to encourage oralists to keep it up and take advantage of opportunities like this in the future. Thank you very much.
All right. Thank you so much, sir. Now, let me just add up one thing. Learned councils, you all did well. I must appreciate and celebrate your candor. You are going to be advocates in the nearest future, and just shows that you are getting there. However, I have oralist 2, team 16. My grouse with you was the fact that you were debating, not arguing. You were debating. Can you hear me, oralist 2? Team 16, that's the respondent. You were debating, oralist 2, and not arguing. In court, you don't debate. No matter how your words sound, the court needs to be convinced of the things you're saying. So I think you need to work on that so that you will learn the act of advocacy. But in all, I must commend both teams. You all did very well. All right, you might not exit, team 16 and team 18. Thank you so much.
Hold on, please. I just got this. I don't know. I would want the respondent, team 16. Are you here?
Team 16 is still here.
Hold on, team 16. It appears that the second oralist is appearing in this competition for the first time. That means in the first session you had, Bamidele Ogundiji was not an oralist.
Your Excellency, I was the oralist 2. Yes, Your Excellency, I was the oralist 2 on Monday.
Okay.
Tuesday.
You may exit.
Oralist.
Okay, you may exit. Thank you very much.
Okay. Milord, sir. Milord is online. I don't know if Milord has one or two things to say, sir. Milord, sir.
Well, I'm still observing the students right now. I believe that there was a lot of just memorizing and putting it down. I believe that maybe they should be more calm, more measured in their tone, and they should highlight the points that they want to, or the issues that they want to speak about clearly, so that one can follow them properly. There's a lot of just mixing everything up. They should be able to highlight, oh, I am going to speak on issues so, and so. And my co-presenter or whoever will speak on issues, and then they should take it one at a time. I could see that doctor was cautioning one of the lady. I mean, they understand what they are saying, but to carry the panel along, they have to ensure that because there's a panel that will score them anyway. So I believe at this point, those are just my observations. But they know their stuff, but they must be able to convince the panel. That's what it is about. There are no right or wrong answers in this. It's how you are able to convince the panel on your points. I think I will stop here for now.
Thank you so very much, sir.
Thank you, sir.
Thank you, my lord, sir.
Thank you, my lord. Okay, I think we can now call it a close for today. For this session, there's another session afternoon. So thank you very much.
All right.
So you get our score sheets very soon, ma.
Then the score sheet. The score sheet.
Yes.
The score sheet. Yes, sir. I was going to ask this question. From the score sheet, you have applicant and respondent, or at least one surname, or at least two surname.
Okay, other names are to be included. Other names are to be included. So on the score sheet, for instance, for the applicant for today, on the part of oralist 1, you have Akorede Olasupo. And on the part on oralist 2, you have Favor Adebayo, and it will be for the applicant. So for the respondent, which is another score sheet, you have Abdulmojid Omoyemi. For oralist
Okay.
1 and oralist 2, you have Bamidele Ogundijo. That's how it.
Okay. So we are presenting 2 score sheets.
Yes, exactly, sir.
Okay, 1 for the applicant, 1 for the
And
respondent.
1 for the respondent.
Okay.
Yes. And also, we must also put our comments. It's important we have our comments just close to where you have the scoring guide. There's a portion for the comments for each oralist and
Okay.
the name of the judge and the signature. The reason is because we are sending this score sheet to the oralists. They need to see where they need to improve on.
All right. Thank you so much. That's fine.
Thank you, sir. Thank you.
Thank you, ma. Have a wonderful day. My lord, thank you so much, sir.
Bye-bye.
You too, sir. Thank you, sir. Thank you, my lord.
Thank you.